SJC-12036, Commonwealth v. Donald, Dustin.
Mr. Worry, is it Warriors?
Warriors, Your Honor.
Good afternoon.
Good afternoon. May it please the Court, my name is Michael Warriors. I represent the defendant appellant in this case, Donald Dustin. Mr. Dustin appeals from his conviction under Massachusetts General Law 265, Section 13M, for assault and battery on a family household member. The Commonwealth alleges that the victim in this case is Stacy Rock, someone that he had a substantial dating relationship with at the time of the alleged incident. And that's how this case is coming before this court on direct appellate review, is what the Commonwealth needs to prove at trial to establish a substantial dating relationship. And in this case, we're arguing that they were insufficient in the evidence that they brought forward to make that proof.
If we take the position that the motion for a required finding was too late, so that we look at the defendant's case in this case, where does that get you?
Well, certainly the case was, on the Commonwealth's case, was insufficient, where it was just evidence that he called her girlfriend. I don't think it deteriorates when Mr. Dustin presented his case by calling himself and the alleged victim, who discussed this friendship relationship that they had.
Didn't he go into detail about why they were so friendly and this is just a misunderstanding, basically?
Well, they went into detail of their friendship and that they provided each other friendship rings, but they didn't get into the frequency of the relationship. They never discussed when they became boyfriend and girlfriend in their mind. There was no level of intimacy that was presented in evidence in this case, no evidence of a sexual relationship.
He
and no
nursed
evidence.
Her back to health from some procedure she had? I mean,
I think that evidence is a strong friendship.
a whole lot of time together?
In Ms. Rock's own words, they asked her to describe it, and she said, we're good friends. I think that a friend who takes care of a friend would definitely be considered a good friend by the one who was ill.
I thought it was they developed a friendship, a relationship, evolved into boyfriend, girlfriend, and they began dating. That
is correct, Your Honor. But she did describe him as a good friend. They asked him about the relationship. He said it was a good relationship, that they had a great relationship.
Exclusive with one another, wasn't that the testimony?
There was, and there was no evidence when they became exclusive or the frequency of their interaction since they became exclusive when they began to date. In this case, I think that the statute is clear. There are 5 factors that the court or the trier of fact, I apologize, should consider. And it says here that they shall determine whether a relationship is substantial by considering these 5 factors, that the type of relationship, the length, and frequency in this case were all deficient. I also argue that if the court were to hold that the government does not need to show affirmative evidence on each of these 5 factors, that the statute would be, as the amicus argues in this case, unconstitutional. But I do take the position that the statute is constitutional should this court interpret it strictly and require affirmative proof on each of these 5 elements. So in regard to length here, we know nothing. In regard to type of relationship, we hear a lot about a friendship that became more, but we don't know how it did, when it did. And then lastly, obviously the frequency of their interaction, we don't see anything of it all. In my opinion, this case is very close to the 209A case found insufficient of CO versus MM. In that case, there was evidence of a couple spending time together at a house. The mother said that he's at the house visiting my daughter, that they go out to the movies, but nothing more. And in this case, what we know about their dating is very similar to that. And I think it's directly distinguishable from the cases of ECO versus Compton and Broussard versus West Roxbury Division of the District Court.
So you think that all these factors have to be satisfied?
Yes, Your Honor.
So if there was testimony as to the length of the relationship, if someone testified, we've been married for 70 years, and there was no further testimony, that wouldn't be evidence of a substantial relationship?
Well, marriage would not need to go under that category.
Well, bad example, we've been together for 70 years. I'm saying if there's some extreme evidence on just one factor, isn't that enough?
I would argue in this case it wouldn't, because we would need to know if they're still living together. People can or be living together. They could be separated. They could not be seeing each other. They could be reconnecting. And I think that what the Broussard court says is that we're not going to include all types of relationships that are happening in society, but we're going to have to look at these factors and consider these factors in order to reach a conclusion of a substantial dating relationship.
But it says, going to Justice Gaziano's question, the statute goes into considerations of the following factors. Doesn't that suggest that you don't have to satisfy each one, but you look at each of them and see if they're satisfied, or look at the totality of the circumstances at least, taking into account the factors?
I think the legislature could have included language that would have said that just that point, or to say something as such of including but not limited to these factors. But here it seems to be that to get around the constitutional ambiguity that the amicus raises, that these factors must be considered. There must be affirmative evidence on each of these factors in order to reach that conclusion, because there are several types of relationships in society, and they're constantly evolving, that people are having with one another, and not all of them are going to be covered by this law.
But it can't be that. One of the factors is the type of relationship, right?
Correct.
What if the answer is, well, we're in a really substantial dating relationship? I mean, they mean that colloquially. I'm serious. It has to. It can't just be you have to satisfy all of them.
Well, I think the problem can be easily remedied by the manner in which the Commonwealth presents its case. I mean, the first step I would do if I was in district attorney's shoes trying a case like this would be to look at the statute. What do I need to show? And ask those questions. I don't think it presents an onerous burden upon the Commonwealth to ask a question about when did they meet, how often do they see each other, do they have intimate relations, romantic relations, those type of things. I think it would really come down to that. And that was what was distinctly missing from this case.
Well, it's not so onerous when the purported victim is testifying. It becomes a lot more onerous when the purported victim, for whatever reason, does not choose to testify. And then you have to prove through third parties about the nature of their relationship, so who may or may not know whether they have a sexual relationship.
I guess one thing to consider, Chief Justice, about this statute is it doesn't provide any further sentencing penalty than just the regular assault and battery. The choice of the government was to go forward in this case, and I don't know the answer for why they chose that, but they chose to go forward under this household family member statute versus straight assault and battery, where the sentence would be the same. I mean, I would argue that having this on your record looks worse because it does label you as an offender of a household family member, which isn't even true in this case because they didn't even live together, but it does have that look on your query after.
But does the government have a right to select what charges they want to bring?
It does, but I would say in with that is the need to prove its case, to look at the statute and submit affirmative evidence on each element that it needs to prove.
Would it be enough if the government proved that there was a sexual relationship between the two people? Is that important? Is that required under your view of what's missing?
I don't know. Obviously, there are relationships of dating where people could be abstinent, of course, that they wouldn't have a sexual relationship, but there could be some level of intimacy. But I looked at the cases I looked at, like ECO and Broussard, they looked at that as being very central. They did look at the intimacy of the relationship, but those cases also talked about the other factors as well, the frequency of the relationship. And so the case law the body of case law is all from the 209A under the civil standard, but I think it's instructive on what evidence fills these factors to find the substantial dating relationship. If there's nothing further, I'd rest on my brief.
Okay, thank you. Ms. Johnson, good afternoon.
Good afternoon. May it please the court, my name is Melissa Johnson. I'm an assistant district attorney in Middlesex here on behalf of the Commonwealth. I just want to clarify a couple of things that my brother had said. First, As far as the penalty, he said that they were exactly the same as, I'm assuming he's comparing it to simple assault and battery under 13A. There's just a couple of differences. Number one, the fine is higher for a 13M domestic assault and battery. It does mandate a batterer's program. And probably the most significant thing, the significant difference with 13M is now there is a second and subsequent penalty, which could call for up to 5 years in state prison or the 2.5 years in the House of Correction.
Was the evidence insufficient if we freeze it at the time that the Commonwealth rests?
Absolutely not, and that is why the Commonwealth had argued it both ways. As far as when we freeze it at the Commonwealth at the end of our case, of course that was not done here properly, or if you take the entire case.
I guess the first question is harder, so give me
Yes.
the evidence that supports your theory before the Commonwealth rested.
First and foremost, Your Honor, the defendant said, "This is my girlfriend." And the reason that I was driving like a maniac was because we had just gotten in a fight, and I'm really pissed off about it. Second, the victim, her actions, her demeanor, she was very protective of him. She was protective of him with the eyewitness. She was protective of him with the police. So we have those factors. We have the emotional, heated argument that was overheard in the parking lot. And it was in a parking lot of Price Chopper, which is typically a place where an established couple would do mundane errands. Taking all of these pieces of evidence together and looking at the Lattimore standard, which requires the judge to view all of it in the light most favorable to the Commonwealth, including all of the inferences from the evidence, a reasonable juror, hypothetically speaking, could find that they were in a substantive dating relationship. And that brings me to another thing that I wanted to clarify as far as what my brother said. These are factors. They are not elements that the jury considers. And CO versus MM made that very clear. These are factors. Really, yes, Your Honor.
No, finish your sentence. I shouldn't.
They are factors. The Commonwealth does not have to hit on every one of them. They are considerations somewhat like a juror might have to consider extreme atrocity and cruelty in a first-degree murder case. We don't
have to find one of them.
Have to find one of them, yes. And however, the juror doesn't have to be, or the jury doesn't have to be unanimous on which one it finds.
But that's sort of getting to my question. They may not be that you have to, I mean, with due respect to your brother, that may not be that you have to have evidence hitting every single one of them, but they somewhat define the universe of what a substantive dating relationship is.
Yes.
And I guess the gap between looking at those factors somewhat holistically and the evidence that you have just outlined, and I'm not persuaded by the evidence that being in the parking lot of Price Chopper somehow is a factor. So I'm just not counting that one. But the other ones, there's just such a big gap between that and what this is getting at that I guess I'm having trouble with I'm not sure you have to get there, but I'm just having trouble with the idea that at the end of the Commonwealth's case, you actually had enough.
Well, Your Honor, I think this is a time where I really would like to stress the Lattimore standard, and I think that Chief Justice Gantz had hit on this in the first portion of the argument, is that typically in these situations, we are going to have to prove this relationship circumstantially, inferentially, because if it's going to trial, we probably don't have the victim on board. So taking all of the inferences from these pieces of evidence together, those inferences taken in favor of the Commonwealth suggest that the nature of the relationship is intimate, it's romantic. He's saying, "This is my girlfriend." There's an emotional connection because he is upset. He's driving like a maniac. She's upset because she's trying to protect him from the police. So clearly that piece, the nature of the relationship, is clear enough in terms of to satisfy a Lattimore standard. There's another piece of it, if the relationship has been terminated. Well, it appears that it's still ongoing at that point because they're still together. So like I said, is it the strongest on each one of these? No, but the Lattimore standard at this point, if we freeze it at the Commonwealth's case, there is enough to get it to the jury, to a reasonable juror, to get to that point where they find a substantive dating relationship beyond a reasonable doubt.
I guess along those lines, we tell jurors all the time to use their common sense.
Yes.
So what does she say? She says that she's the girlfriend, right?
He says,
Girlfriend.
yes.
So what's common sense say when you tell the jurors to use their common sense about the type of relationship?
That it's a romantic, intimate relationship.
I mean, you got to use common sense. And so girlfriend. And so we tell jurors.
And they are, just like when I was referring to the extreme atrocity and cruelty, they are the conscience of the community. They're bringing their common experience as to what's going on and looking this whole chain of events of what's going on, from the heated argument in the supermarket parking lot all the way to the scene of the arrest. What's really going on here? Is this a couple?
So if that's wrong, and you don't have enough, even with all the reasonable inferences, and the curtain comes down at insufficiency, and then the defendant fills in the holes, so then it's a motion for new trial on ineffective assistance of counsel?
That's an interesting question, and I certainly wouldn't say that there is ineffective here because, number one, I don't think the motion would have been allowed at the time. I think it was the strategy of this defendant to put in that relationship from the very beginning. There was a motion in limine, even before trial started, that the defendant wanted to highlight how strong and intimate this relationship. They were intertwined in each other's lives every day. And it was a strategy that was effective because he got an NG on the strangulation. And even with the A and B, the defendant admitted that he pushed his girlfriend. So the issue that the jury was really trying to work through was perhaps a self-defense issue. To be honest, our burden was met pretty easily there. So this was really, considering what the evidence was, a good outcome for the defense attorney to use that strategy to highlight the relationship. But I do understand that, I think in terms of our position is that it is a substantial risk of a miscarriage of justice, and all of this should be looked at together because the motion for required finding was not timely made, and you can't just move whenever you like to. It's not a moving target. 25A, Rule 25A requires that it either be at the close of the Commonwealth's case or it be the close of all of the evidence. And if it's made at the Commonwealth's at the end of our case, then it has to be ruled on there. It's fairly clear. So it can't be just made any time. And I think that probably would pose a problem for this court and the appeals court to figure out what chunk of evidence are we reviewing here. So in terms of just the technical precision of how this case should be reviewed, it is a substantial risk of a miscarriage of justice because that motion was not made timely. And if we are going to be true to what that standard is, it's really looking at the entirety of the evidence, which, as perhaps you seem to acknowledge, got much stronger when the defendant and the victim testified to their wonderful, beautiful, established boyfriend-girlfriend relationship of several months, which seemed to indicate that that was a substantive dating relationship. I see that I have a little time left. If I could address our motion to strike the amicus brief in the very few minutes or the very few seconds I have left. This was filed. This is not a party. This was unsolicited. And it was an issue that was not raised by either parties. But I do believe this court can easily dispense of that argument with its decision in CO versus MM, where this court had scrutinized that very language, said that it was well-crafted and well-structured language to give judges a way to make an informed and consistent determination. So this court has already reviewed that language, has determined it was not ambiguous. Just because a factors test may be flexible doesn't make it ambiguous. And for that reason, any kind of rule of lenity doesn't apply. So if there are any questions on that, I'd be happy to answer them. If not, we'd ask you to affirm the defendant's convictions. Okay. Thank you.